Hello everyone, this is Rishabh and you are watching Company360.in. Today we will be talking about the trade secrets in India versus the USA. In the present scenario, trade secrets protection is primed to encourage innovative steps, foreign investment, and to promote healthy competition. Trade secrets give the commerce a spirited edge over the competitors, and thus one must make sure that he or she adequately protects his or her business-related confidential information from their competitors. Trade secrets as a new form of intellectual property could be very substantial, and it is garnering wide significance because in the area of globalization, the failure or success of any company depends on its secrets allow them to be policies related to secrets or information of their clients. Introduction. A trade secret is a piece of information not generally known or reasonably ascertainable that offers a business an economic gain or advantage over its competitors. It simply refers any data or information relating to the business which is not generally known to the public, and reasonable attempts has been made to keep the information secret and confidential. Trade secret protection needs reasonable efforts to maintain secrecy. However, there are also some disadvantages to the protection of secret information. The producer will maintain secrets about the research until it can be protected by means of the law of patent, thereby leading to a great deal of duplicated research which isn't always efficient. These considerations need to be kept in mind while deciding what information should be protected. In certain circumstances, it has been decided that the misuse of secrets should be considered for taking action. If the disadvantage outweighed the advantages, the civil law should not intervene. Trade secret under NAFTA. According to the North American Free Trade Agreement (NAFTA), a trade secret defines an information having commercial value which isn't within the public domain, and that reasonable steps have been taken to maintain its secrecy. Trade secret means information including a formula, pattern, complication, program, device, technique or process that number 1. Derives independent economic value, actual or potential, from not being typically regarded to and not being readily ascertainable by proper means, other persons who can obtain economic value from its disclosure or use, and number 2. It is the topic of efforts that are reasonable under the circumstances to take care of its secrecy. Trade secret under TRIPS agreement. Article 39 of the Trade-Related Aspects of Intellectual Property Rights (TRIPS) states 3 norms for in view of any information as undisclosed information. Those norms or conditions are as follows. A. The information isn't as a body or within the precise configuration and assembly of its components, generally known among or readily accessible to persons that normally affect the type of data in question. B. The information has actual potential or commercial value because it's secrets. And C. The person lawfully in control of the information has taken responsible steps under the situations to make it secret. Essentials of trade secret. Number 1. A trade secret is not readily accessible. Number 2. The trade secret must have commercial value as a secret. Number 3. Lawful owners must take necessary steps to retain secrecy. Number 4. Of the famous trade secrets include recipes, algorithms, computer programs, manufacturing processes, technical information, and etc. How long does trade secret last? Number 1. If the information continues to meet the norms and if it is not revealed, it remains a trade secret. Number 2. The indefinite lifespan means that the trade secret can be very much valuable asset for any company. Number 3. However, rights in trade secret only exists as long as the secret is maintained. Protection of confidential information. A person who receives valuable or secret information in confidence owes an obligation or duty referred to as a duty of confidence. neither to disclose nor to make use of that information for any use other than that for which the disclosure was made without the consent. Should the receiver of such information threaten to do so, the person who imposed it on him or her is entitled to an injunction to restrain such unauthorized use or disclosure. Confidentiality is an ethical principle associated with several professionals who are privileged and may not be discussed to third parties. In those jurisdictions in which the law makes provision for such confidentiality, there are usually penalties for its violation. V. N. Deshpande versus Arvind Mills. In this case, court considered a clause concerning the confidentiality of the information and stated that a clause, namely clause 9 of the agreement, prevents the appellant from divulging any secret information of such nature mentioned therein clause after getting termination of his service. The defendant isn't prevented from acquiring knowledge, which makes him a far better employee for the general public for future employment, but it only prevents him from divulging information which has received as respondent's employee to a different party. Hence, it is clear that the clause as worded is proper and injunction granted in terms thereof is not unreasonable or wider latitude than just justified in law. Difference between trade secrets and confidential information. Brown versus Rollet Bros Trucking. In this case, the court made a distinction between access to an actual trade secret and less valuable confidential information. The latter is not amenable to protection through a non-complete. In this case, access to a rate sheet listing his ex-employer's shipping rate and fuel charges has been given to a dispatcher. That sheet was adjusted at various times, sometimes monthly and sometimes annually. Relying on Ling standing Missouri precedent, the court observed that this type of confidential information was not a trade secret. In so holding, the court specifically noted the key difference between the two legal concepts, that is, confidential information is usually limited to one or ephemeral event within the conduct of a business, whereas a trade secret is maybe a processor device for continuous use in the operation of a business. Concerning pricing out a customer job, a trade secret is frequently found if the employer uses a specifically developed code or formula to churn out bids. However, as it was in the Brown case and in countless other fields, pricing information is often fleeting, with sales managers given huge discretion to match a complete's bid or adjust prices based on fluctuating cost of materials. Protection of trade secrets in India. In India, trade secrets are a most ignored field as there is no proper policy framework for the protection of trade secrets. Trade secrets in India are protected mainly through contract law or through the equitable doctrine of breach of confidentiality. It is commonly to insert clauses in an agreement with the employees that protect the confidentiality of the secrets of the company not only during their employment period but also after they are terminated. In the case of Atwood versus Lamotte 1920, it was stated that one of the principles is that a master is not entitled to stop his or her servant after the determination or termination of employment from offering competition, but he is entitled to a reasonable protection against exploitation of trade secrets. The Indian Contract Act 1872. The Indian contract relies on common law remedies for the protection due to the lack of law for the protection of trade secrets. Reliance is placed by Indian courts on the case of Saltman Engineering Corporation Limited versus Campbell Engineering Corporation Limited 1948, where the issue is of confidential information, whether or not a manufacturer owed a duty of confidence to a company who had supplied them drawings and designs to produce tools to make a leather purchases. Basically, India has the Indian Contract Act to be relied upon for the protection of the trade secret. Section 27 of the Contract Act provides remedy and restrictions to a person from disclosing any information which he acquires at the time of employment or through a contract, but there is not a single provision of criminality remedy in it. According to Section 27 of the Contracts Act, confidential information must be highly confidential before it could be considered a trade secret. It also decides whether information amounted to a trade secret or not. There are the following relevant factors for the same. Number 1. The nature of the work of the employee and his status. Number 2. The nature of the information itself. Number 3. Whether the employer impressed by the confidentiality of the information on his employees. Number 4. Whether the information could easily be isolated from other information which the employee was free to use. An employer can prohibit lawfully his employee from accepting, after determining his employment, such a position where he is likely to utilize the information of secret processes and trade secrets acquired by him during the course of employment. He can also covenant to ban his employee from fixing up his own or accepting employment with the employer's competitors likely to destroy the employer's trade connections by misuse of acquaintance with the employer's clients. Copyright Act 1957. In the case of Burlington Home Shipping Private Limited versus Rajneesh Chibbar, court observed that the law of trade secrets tries to protect a good range of business data. Customer lists and other compilations of business data could also be copyrightable as a fact of work. Law of trade secret and law of copyright protect different sections of compiled business data, with copyright protecting the expression in these compilations and trade secrets law protecting the underlying data. However, the protection of copyright and trade secrets for compilations of business data frequently converge. In this specific case, the defendant was restrained from using the database of plaintiff consisting of a compilation of the address of clients. The court held that if the defendant is permitted from the use of the database of plaintiffs, it's bound to cause an injury to the plaintiff, which might be incapable of being estimated in terms of money. SEBI. Number 1. SEBI has issued SEBI Prohibition of Insider Trading Regulations 1992, which renders use and disclosure of confidential information by an insider subject to protection under SEBI Act of 1992. Number 2. In one respect, this regulation also crystallizes the obligation of confidential arising out of the relationship between an insider and the company, and in certain cases will protect information qualifying as trade secret. Number 3. However, a third party who makes use of this information is not made liable. Number 4. It was observed that in case of activities like insider trading, fraudulent trade practices, and professional misconduct are absolutely detrimental to the interests of ordinary investors and are strongly deprecated under the SEBI Act 1992, and therefore the regulations made thereunder, no punishment is to serve those indulging in such activities. IT Act 2000. While the Information Technology Act of 2000, IT Act has provisions regarding the cyber and related IT laws in India and delimitates the scope of access that a party may have to on data stored on a computer system, or computer network. The provisions of the IT Act don't address the need for a stringent data protection law being in place. The Information Technology Act 2000 has recently been amended to satisfy challenges in cybercrime. It has introduced two important provisions that have a robust pertaining to the legal regime for data protection. These are sections 43A and 72A inserted into the IT Act by the Amendment Act. However, this Amendment Act hasn't specified the meaning of the term sensitive personal data or information, and merely states that it had mean such a personal information as could even be prescribed by the Union government in consultation with such professional bodies or associations because it is going to deem fit. Design Act 2000. In this case, a picture emerges that the court shall entertain injunction only as long as an equivalent is protected either through copyright or designs alongside a non-disclosure agreement. Civil Procedure Code. The trade secrets during the proceedings can be protected and there is no compulsion on plaintiff to disclose the details during litigation. However, disclosures may be sought to either of the parties against each other to disapprove the fact as to whether the information was confidential in nature and was shared with the defendant under such understanding. Indian Penal Code. In a case, the respondent contending that the action of the petitioners amount to criminal breach of trust and cheating because the technical expertise know-how acquired by the respondents amount to property, filed a criminal complaint. Court did not answer the question of whether or not trade secret amounts to being a property because the case had not satisfied the other conditions for attracting criminal liability. The plaintiffs did not prove the dishonest intention on the part of the appellants. The court evades choosing on whether it might amount to property. But the court had made an observation that if the petitioner uses the technical know-how in contravention of the agreement of service, then sections 408 and 420 are often attracted. But because the burden of proof is much higher in criminal cases, its scope is minimized. National Innovation Act 2008. Number 1. National Innovation Act of 2008 has been released by the Department of Science and Technology. Number 2. The government in the pursuance has invited comments to the same. Number 3. The aim of the National Innovation Act of 2008 is to push to innovation and exploitation of technology, bridging the gap between innovation and the lack of it in the present patent law. Defining and dealing with the new inventions satisfying the criteria for utility, novelty, non-obviousness and industrial applicability, the Patent Act does not allow innovations to be exploited under its provisions. Objective of National Innovation Act 2008. Number 1. The preamble of this act aims to aid innovators and researchers exploit the fruits of their innovations to the maximum possible extent. Number 2. The preamble reads as an act to facilitate public-private or public-private partnership initiatives for building an innovation support system to encourage innovation, evolve a nation, integrated science and technology plan, and codify and consolidate the law of confidentiality in aid of protecting confidential information, trade secret and innovation. There was a bill proposed called the National Innovation Bill of 2008 in which the Chapter 4 talked about the confidentiality of information. It broadly says three things, which are as follows: confidentiality, misappropriation, damages, and injunction. Describing what aims and objectives to be included in the ambit of an innovation, the draft legislation states innovation to be a process for incremental or significant technical advance or change which provides enhancement of measurable economic value and shall include introducing new or improved goods or services, implementing new or improved operational processes, implementing new or improved organizational, managerial processes. Further, court may restrict any person or class of persons impleaded in an action not to disclose the confidential information mentioned in the claim without prior orders of the court. Additionally, there is a provision which provides exceptions in these conditions. Confidential information shall not are misappropriated where the confidential information was available within the public in large, or the confidential information has been alone derived by the alleged misappropriation or by any third party from whom the alleged misappropriator received the information, or where disclosure of the confidential information is held to be in the interest of the public by a court of law. But this draft could not come into existence. Protection of trade secrets in the USA. In the United States of America, the irrelevant laws for prohibiting unauthorized commercial use of the trade secret are as follows. Uniform Trade Secrets Act (UTSA). The most important goal of the UTSA is to make the state laws that govern the trade secrets trade uniformly, especially important for those companies that operate in more than one state. Uniform Trade Secrets Act defines trade secret as information consists of a formula, patent, compilation, program, device, method, technique or process that: Number 1. Procedure independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who may obtain economic value from this disclosure or use. And Number 2 is the subject matter and efforts that are reasonable under the circumstances to maintain its secrecy. To decide what amount or forms of safeguards are reasonable to guard the secrecy of proprietary information. For this, there's no clear-cut formula. In the Economy Roofing and Insulation Cooperative versus Zumaris, the court said that there's virtually no category of information that cannot, as long as the information is protected from disclosure to the public, constitute a trade secret. Number 3. Section 5 of the Act says that in action under UTSA, a court shall preserve the secrecy of an alleged trade secret by reasonable means, which may include granting protective orders in reference to discovery proceedings, holding in-camera hearings, sealing the records of the action, and ordering a person involved within the litigation to not disclose an alleged trade secret without prior court approval. The UTSA has also defined the definition of improper means and misappropriation. Economic Espionage Act 1996. Under the Economic Espionage Act of 1996, information will be considered as trade secret if A. The owner has taken reasonable measures to keep such information secret, and B. The information derives independent economic value or actual or potential from not being generally known to and not being readily ascertainable through proper means by the general public. The requirement not being generally known to the public or other persons does not require that information be generally known to the public for trade secret right to be lost. If the principal person one can obtain economic benefit from information is conscious of its, there's no trade secret. If a company discovers a competitor's trade secret through proper means, the secret will be known as two companies but will not be generally known. In a case of the United States versus Genovese, the court held that the trade secret does not lose its protection under the Economic Espionage Act if it is temporarily, accidentally, or illicitly released to the public, provided it does not become generally known or readily ascertainable through proper means. Further, the Act has provision to punish the provider and the receiver of unauthorized trade secrets. The doctrine of inevitable disclosure. Some of the US courts have recognized that trade secret misappropriation is inevitable. If an employee with knowledge of a company's specialized trade secrets accepts an equivalent position with a competitor, in that situation they find that the employee who wants to do good work will inevitably rely on whatever he knows, which also includes the former employer's trade secrets. In a famous case, an employee was prohibited from working in a particular field because he had worked as an engineer in the plaintiff's spacesuit program and then left to work for a competitor in the same area. It was held that it would be impossible to perform these managerial functions without relying on his knowledge of the plaintiff's trade secret. In the case of PepsiCo Incorporated versus William Redmond, the defendant, William Redmond, worked for PepsiCo from 1984 to 1994. Redmond became the manager of the Northern California business unit in June 1993. He got promoted 1 year later to general manager of the business unit, which covers all units of California. Redmond's relatively high-level position at PCNA gave him details of access to inside information and trade secrets. Redmond, same as other PepsiCo management employees, has signed a confidentiality agreement with PepsiCo. Afterwards, he joined a competing company known as Quaker. Against this, PepsiCo filed a suit, seeking a non-permanent restraining order to enjoin Redmond from assuming his duties at Quaker and to stop him from disclosing trade secrets or confidential information. The district court issued an order enjoining Redmond from assuming his position at Quaker through May 1995 and permanently from using or disclosing any trade secrets or confidential information. The court found that Redmond's new job posed a transparent threat of misappropriation of trade secrets and confidential information that would be enjoined under Illinois statutory and customary law. Against this, an appeal was made to the United States Court of Appeals for the 7th Circuit. The 7th Circuit affirmed the district court's order. Inadequacy of sui generis laws for trade secrets in India. In India, trade secrets protection is largely based on common law. The law relies on common law principles like the breach of trust and breach of confidence. The only statutory provision governing trade secrets law, Section 27 of the Indian Contract Act, which states that every agreement by which a person is restrained from carrying on any trade, business, or professional is invalid. This provision brings within its ambit non-disclosure and non-compete agreements, which are indispensable for the protection of trade secrets, may be located including the Securities Exchange Board of India. Prohibition of Insider Trading Regulations 1992, which renders the use and disclosure of confidential, undisclosed information by an insider subject to prosecution under the Securities Exchange Board of India Act. But there is no uniformity in the views of the courts over this issue. Unlike the US, there is no provision for criminal liability in India. There is no established law when information is improperly obtained. In a case, it was held that equity would only supervene if the information had been communicated in circumstances importing an obligation of confidence, but the case was silent as to the applicability of the principle in other circumstances, like when the information is obtained surreptitiously. Conclusion. Though a law of trade secrets fit into existing framework of the law of contracts and other laws, there are certain problems with respect to its inception in the field of intellectual property rights. Therefore, separate legislation for trade secrets might do away with that disparity as well. India, being a growing nation, has to have a sturdy regulation for shielding or protecting trade secrets. The TRIPS agreement mandated its member states to have alternate their legal guidelines and convey new legislation to satisfy the obligations as under the TRIPS agreement. It is time for a statutory law to come into force in India that not only protects trade secrets and confidentiality but also makes suitable amendments regarding the same. The criminal law of the country, the Indian Penal Code 1860, also needs amending that provides for criminal liability in case where there is a breach of confidence or disclosure of trade secrets, just like what exists in one of a similar countries. The mere presence of criminal law does not act as deterrence for individuals who indulge in such practices, and accordingly intensive action and practice likewise had to maintain such incidents at bay. Therefore, for protection of trade secrets, a transparent, clear, and definite policy within regard to trade secrets protection is need of the time. This clearly underlines the need for comprehensive legislation on trade secrets in compliance with Article 39 of TRIPS. The provisions provided under the Uniform Trade Secret Act and Economic Espionage Act 1996 in the US must be followed in India also. Therefore, legislation that provides a civil, also criminal liability should be put into practice. Indian legislature should take recourse of the provisions laid down under the UTSA and EEA in the US. Want to get legal services for yourself? Company360.in provides you with all the necessities required for these procedures for a very reasonable price. If you still have some questions, feel free to put them down in the comments section. Or you can find us at www.company360.in or email us at info@company360.in, or you may even call us at 964-334-0938. Thanks everyone for listening. This was Rishabh. Until next time.